Thank you, Professor Hansen, and many thanks to this class of students for inviting me to speak here today. I really do feel honored and privileged to be here, and I've heard very good things about this class. During my 20 years with the National Prison Project of the ACLU, I've worked on almost every issue relating to prisoners' rights and over-incarceration. And I've learned what a powerful tool litigation can be for helping to bring about social change. The very worst prisons are the hardest to see into. A New York Times reporter can't gain entry into a hellhole prison in Mississippi, but lawyers with a civil rights class action case can walk in right into the heart of that darkness and explore every corner of it and document and share with the world what we find there and petition for a remedy, both in the court and in the court of public opinion. When people learn the truth about what really happens inside the prison, that information can transform their worldview at a very deep level. As human rights lawyers, the audience we want to reach isn't just the judge or the jury. It's the people who may become inspired through learning about the lawsuit to work for social change. That's the kind of lawyer I wanted to be when I went to law school. I went to Georgetown Law a long time ago, where I was a really mediocre student. I earned no honors, and I graduated with no particular skills. And that's a kind description of my career. But I did have passion, intelligence, and courage, and I knew a lot of Homer and Shakespeare and the Bible by heart. And through great good luck, those qualities were enough to get me invited to join the litigation team in a big case under the Federal Tort Claims Act against the FBI and the US Attorney General for spying and playing dirty tricks against a small socialist political party for its peaceful anti-war activity during the Vietnam era. The case was Socialist Workers' Party versus Attorney General of the United States, and the lead counsel was Leonard Boudin, an eminent lawyer and a very great champion of civil liberties. However, only 2 weeks before trial, Mr. Boudin and the plaintiffs parted ways over an irreconcilable difference in trial strategy. The plaintiffs asked me to step in and ask as lead lawyer. I knew that that was completely crazy. I had never done any kind of a trial, not even nothing, let alone act as lead counsel in quite a big case in federal court in the Southern District of New York. But I let myself be talked into it. I figured it must be my destiny, and I agreed. The trial lasted for 3 months, and I thought many times that the stress, anxiety, and terror of that experience would kill me. But it didn't, and we won the case, and I was hooked for life on using litigation as a vehicle for social change. So now I'll tell you a few cases from my years in the ACLU. Fast forward several years, and I got a job with the ACLU National Prison Project. My first day on the job, I was asked to take over as lead counsel a class action case on behalf of all HIV-positive prisoners in Alabama. The case was a challenge under the Rehabilitation Act, which was the precursor to the Americans with Disabilities Act, challenging Alabama's policy of testing all prisoners for HIV when they entered the system, and then categorically segregating all prisoners who tested positive, and locking them up in a dungeon inside the prison and warehousing them for the rest of their term in prison, which in some cases could have been life. The judge in that case was the Honorable Robert Varner, who loathed and feared Black people, gay people, and people with HIV, and he didn't care who knew it. He put the case on an alarmingly fast track to trial. On the first day of trial, Judge Varner interrupted my opening statement by roaring to the bailiff, "Bailiff, remove that woman from the courtroom." And the bailiff led me out into a vestibule where I cooled my heels for several minutes, hoping and believing that they were going to take me to a nice, safe jail cell for the duration of the trial, and I would be able to, get away from Judge Varner. But no such luck. I was summoned back into the courtroom, and during the next month, whenever the plaintiff's lawyers made an evidentiary objection, Judge Varner would turn to the state's lawyer and say, "Well, David, how do you want me to rule on that objection? Remember, you've got to protect your record on appeal." That's how that trial went down. It was a foregone conclusion that Judge Varner would uphold the segregation policy, which actually he had done before. This was the second trial on remand. For the next 7 years after that, after his decision, we fought a series of appeals in the 11th Circuit until finally the Court of Appeals en banc upheld the categorical HIV segregation policy, and the U.S. Supreme Court denied cert. So that 11th Circuit decision created an absolute res judicata bar for who knows how long, for the Alabama prisoners. And it was also a terribly chilling precedent in the other states that still practiced HIV segregation. So for the next decade, from 2000 to 2010, the ACLU pivoted away from litigation because really the court was closed to us at that point for this foreseeable future, and toward a robust advocacy campaign against HIV segregation. And that campaign resulted in some major concessions, especially in Mississippi, which in 2010, Mississippi simply completely eliminated and dropped its segregation policy and mainstreamed prisoners with HIV as a result of that, direct result of the advocacy campaign. But in Alabama, time stood still. There, HIV still provoked such intense shame and loathing and fear and hatred, all mixed up with race and class prejudice and powerful homophobia. The state still continued to house all prisoners with HIV in HIV-only dorms, separated from the rest of the prison by a tall chain-link fence. And the prisoners with HIV were barred from dozens of rehabilitative programs, jobs, and vocational training. The prison's manual of standard policies and procedures suggested that prison staff, quote, wear plastic or latex gloves, face mask, goggles, and protective rain gear before entering the cell of a prisoner with HIV. And all male prisoners with HIV were required to wear 24 hours a day a white armband indicating that they had HIV, which the prisoners referred to as the mark of Cain. We kept pushing for concessions from the Alabama Commissioner of Corrections, but in 2011, we reached the end of the road on advocacy. And the commissioner finally flatly refused to make any more concessions. And at that point, the prisoners with HIV pushed us very hard to bring another lawsuit. And we felt that we just could not refuse. We overcame that res judicata bar by proving material changes in fact, namely that with the new medications, HIV is no longer an inevitably fatal disease as it had been during the last trial, but it's now a chronic disease that can be well controlled with medication. So the new case we filed was called Henderson versus Thomas. In 2012, we went to trial, again in the Middle District of Alabama, but this time the presiding judge was the great Myron Thompson. There were many strange and wonderful moments during the trial, but the most startling was when the state called to the witness stand the Alabama Associate Commissioner of Corrections, James DeLoach. For years, Commissioner DeLoach had been the standard bearer for HIV segregation, its staunchest and most passionate defender. And we noticed during the state's direct examination of Mr. DeLoach that he sounded subdued and uncomfortable. And we wondered what that was about. Where was his old fire? We found out when we cross-examined him, he blurted out under questioning that he had decided during the trial that HIV segregation does not serve any legitimate purpose and should be eliminated. In December 2012, Judge Thompson issued an extraordinarily detailed and, I think, profoundly moving opinion ruling that HIV segregation violates the Americans with Disabilities Act. And that decision has affected every aspect of the daily lives of Alabama prisoners with HIV. And shortly after Judge Thompson's decision, South Carolina, the only remaining state in the nation to segregate prisoners on the basis of HIV, decided to voluntarily eliminate HIV segregation. And that was the end of HIV segregation in the Deep South and nationwide. And it was the culmination of a quarter-century-long campaign by the ACLU to end HIV segregation. So in Mississippi, we also represented prisoners with HIV. In 1999, we got a flood of letters from prisoners in Alabama with HIV saying that they were dying like flies. They were dying by the dozens because the state was refusing to give them the new cocktail, the HIV cocktail that had been introduced in 1997 and was the only, there had never before been an effective medication for HIV. So HIV was simply a death sentence. And with the introduction of the new medications, people were literally getting up off their deathbed. It was a whole new day. But the Mississippi Department of Corrections refused to give the new medication to the prisoners with HIV. So we went into court and we won an emergency injunction requiring the state to provide the HIV medication. But after granting the injunction, the judge, Jerry Davis, almost immediately issued an order permanently barring the ACLU from communicating with any Mississippi prisoner about the conditions of their confinement. And the Fifth Circuit Court of Appeals, of course, overturned that order, but also ruled what was a more difficult question, overruled the trial court who had insisted that the prisoners could not have the ACLU for their class counsel, and the Fifth Circuit ruled that prisoners with HIV must be allowed to have the ACLU as their class counsel if that was their choice, and it was their choice, 100%. In 2002, this was shortly after the Fifth Circuit's ruling in the HIV case, we got a letter from a prisoner on Mississippi's death row at Mississippi State Penitentiary, and that's the notorious and legendary Parchman Farm, which is the subject of song and story in American folklore going back to the beginning of the 20th century. This prisoner who wrote to us, Willie Russell, enclosed a petition from other death row prisoners who were on hunger strike to protest the unendurably harsh and cruel conditions of confinement on death row. They said they would rather die from starvation than let the state kill them through torture. When I went to meet with Willie, he was already several days into the hunger strike, and when he described the conditions on death row, I promised him on the spot that the ACLU would take the case. We shortly thereafter filed a class action complaint, and we got an emergency order to allow us to tour death row with a team of 4 experts during 2 long, scorching days in August, from early in the morning until very late at night. And we were there to gather evidence. We went to trial a few months later, and the testimony of the death row prisoners and of the plaintiff's expert witnesses was very powerful. The prisoners lived in profound isolation, locked down in dark, solitary cells 23 or 24 hours a day, in relentless monotony and enforced idleness. The stench and filth were beyond description. If you flushed a toilet in one cell, the contents of the bowl would bubble up in the toilet in the adjoining cell. And that was every single toilet in every single cell on death row. The cells were like ovens with lethally dangerous levels of heat and humidity. So even going into one for a few minutes, you did not understand how someone could live there without losing their mind. There were clouds of mosquitoes and other stinging and biting insects that made sleep impossible. And the place was like a bedlam. There was a constant din around the clock of mentally ill prisoners with uncontrolled psychosis who were screaming, sobbing, babbling, barking, literally barking like dogs. And although many death sentences in Mississippi are eventually overturned because the representation is so bad during trial, the process takes many years. And there were some prisoners who were simply abandoning their appeals because they couldn't endure the torture, the horror of living in the conditions in death row. Our psychiatric expert, Dr. Terry Coopers, testified that the combination of prolonged solitary confinement with the other toxically harsh conditions in this prison, Unit 32, made prisoners who develop mental illness and those who came in with pre-existing mental illness became psychotic. Some suffered a complete break with reality and they went around the bend and never returned. Our judge turned out to be the very same judge who had entered the gag order against the ACLU a couple years earlier and who had threatened me with sanctions. But he had changed, and we could not have asked for a fairer or better judge in the death row case. He ruled that conditions on death row violated the 8th Amendment, and he ordered the broadest relief that had ever been granted in a death row conditions case up to that time. Even before the trial was over, the death row trial, we started getting a flood of letters from Unit 32, which is Mississippi's supermax prison, where the state housed 1,000 men in prolonged, indefinite solitary confinement. in Unit 32. And some of the prisoners had been entombed there in solitary for decades with no hope of ever getting out. They described conditions as horrible as death row. And the motto in that prison should have been, "Abandon all hope, ye who enter here." As many of you know, in the last few years, there's been a very big national campaign to stop solitary confinement. It has developed very rapidly nationwide over the last few years. But at this time, 10 years ago, that movement was still in an embryonic place. And it seemed to us that the Unit 32 case at Parchman was a good place to mount a head-on challenge. In 2005, we filed Presley versus Epps, and that case became a seminal event in the development of the national movement to stop solitary confinement. The case resulted in a landmark consent decree that greatly limited the permissible justifications for solitary. Within a few months, the population in solitary had been reduced by a stunning 85%, from 1,000 to 150 inmates. And instead of violence breaking out when prisoners were released from solitary into the general prison population, violence plummeted by 70% to a fraction of what it had been. Mississippi's Commissioner of Corrections, Christopher Epps, became a leading national spokesperson against solitary confinement as a result of that experience. The Mississippi experience became known in prisoners' rights advocate circles as the Mississippi Miracle, meaning if Mississippi, the reddest of the red states, can do it, the other states can do it too. Mississippi became a leader in the burgeoning national movement against prolonged solitary confinement. But the Mississippi Miracle self-destructed. As I will explain, stunning revelations over the past week or so show that the private prison industry is deeply implicated in the derailment of the Mississippi Miracle. In 2010, the ACLU and the Southern Poverty Law Center brought suit at the Walnut Grove Correctional Facility, where Mississippi housed kids between the ages of 13 and 18 who had been convicted as adults, so they were doing hard time in an adult prison. The case is called DePriest versus Walnut Grove Correctional Authority. Walnut Grove was built as a private prison, owned and operated by private prison contractors on behalf of the state. The trial judge in that case is the great Carlton Reeves. When we arrived at a consent decree in 2012, Judge Reeves issued an opinion finding a pattern of brutal rapes that was the worst of any facility anywhere in the nation. Guards affiliated with gangs sold drugs on site and staged gladiator-type fights among the youth. Kids who tried to report these incidents faced long stints in solitary. Judge Reeves concluded his opinion approving the consent decree by saying that the combined action of the state and the private contractors, the private for-profit prison vendors who ran and operated the prison, paints a picture of such horror as should be unrealized anywhere in the civilized world. But Mississippi did not heed Judge Reeves' stern condemnation. Instead, within 2 or 3 weeks after Judge Reeves wrote those words, the state entered into a new series of deals with private prison contractors at Walnut Grove and at other state prisons, including East Mississippi Correctional Facility, with disastrous results. So one of these prisons is East Mississippi Correctional Facility, and that's where the state houses almost 1,000 seriously mentally ill prisoners and almost, well, I don't know, 800 of them, no, a couple of hundred of those serious mentally ill prisoners, more or less, are housed in prolonged solitary. The ACLU and Southern Poverty Law Center filed suit there in 2013, and the conditions that we've uncovered there were so horrific that they were covered. They were front page news in the New York Times and other national media, USA Today and other media outlet. 10 days ago, there came an announcement that stunned all of us. Commissioner Epps had resigned, this national figure. And the following day, came the revelation that he had been indicted by the U.S. Attorney on corruption charges involving bribes and kickbacks in connection with steering private prison contractors, vendors, to get operation of prisons in Mississippi. Commissioner Epps has pleaded not guilty. And just last Friday, a week ago, it came out that the private prison corporations have been paid $1 billion by the state of Mississippi over the past few years. This is a big national story, and not just because Commissioner Epps has had a national reputation as a reformer on solitary, on sentencing reform, and that he's fallen from grace. So of course that is the story. But there is if the allegations turn out to be true, and he has pleaded not guilty. The much bigger story, though, which will likely continue to unfold, is about the pernicious, corrupting influence on our criminal justice system of the private prison industry, the for-profit prisons. I'll finish up my remarks by moving from the Deep South to downtown Los Angeles. The LA County Jails is the biggest jail system in the nation and maybe in the world. Men's Central Jail in downtown LA, which is part of this system, is a huge, dark, windowless dungeon, and it really feels like being in a bad dream in there. For many years, there has been an entrenched culture of savage deputy on inmate violence in Men's Central. The deputies, who are the guards within the jail, mercilessly beat helpless inmates. They broke inmates' legs, shattered eye sockets, kicked out their teeth. And a gang of deputies inside the jail. There was even a gang, or more than one, operating inside the jail that called themselves the 3,000 Boys. And they were literally inked up with tattoos and with complete with the hand signals to show their allegiance to this gang of guards inside the jail. They proved their allegiance to this brotherhood by breaking inmates' bones. And inmates with serious mental illness, who the deputies referred to as dings, were prime targets, as were other vulnerable inmates. There had been recurring public scandals over decades about this situation, and many attempts by reformers to clean the place up, but every push for reform had failed. The ACLU of Southern California and the ACLU National Prison Project decided that we were going to gather and drag into the light of day such a mass of evidence of widespread, organized, vicious deputy abuse against inmates that there would be no way to ignore it or sweep it under the rug anymore. And that's what we did. The ACLU of Southern California's jail monitor visited the jails every week, month after month, walking the tiers, interviewing hundreds of prisoners. And we brought in a correctional expert and a psychiatric expert to tour the jail. In 2008, we began publishing a series of reports documenting our findings. The sheriff's spokesman flatly denied everything, and they insisted that the inmates were simply lying. In 2011, we issued a major report that the sheriff could not shrug off. It is called Cruel and Usual Punishment: How a Savage Gang of Deputies Controls LA County Jails. The report was backed up by more than 70 sworn statements by victims and also by highly credible civilian eyewitnesses, including jail chaplains, a movie producer, and the ACLU's own jail monitor, who witnessed a savage beating within a few feet away from her, where a helpless inmate was brutally beaten, and while the two deputies standing over him monotonously intoned, "Stop fighting, stop resisting," to this motionless body. And in January 2012, a few months later, we filed a class action suit against the sheriff, which is called Rosas versus Baca. Baca being Sheriff Baca. The ACLU's report and the lawsuit resulted in a firestorm of media coverage and public outrage. And in response to our Cruel and Usual Punishment report, the LA County Board of Supervisors created the Citizens Commission on Jail Violence, which was a blue ribbon panel of former federal judges and prosecutors tasked with gathering evidence on the ACLU's allegations and holding public hearings and then issuing findings and making recommendations. And a few months later, the Citizens Commission issued a blistering final report concluding that, quote, "the problem of excessive force in the county jails lies with the department's leadership." Over the next 18 months, the blows to the sheriff's department kept coming, one after another. There were federal civil rights probes, criminal indictments and convictions, and jury damages awards in the millions of dollars for the deputies' victims. A federal jury, in an unprecedented verdict, found Sheriff Baca himself personally liable for punitive damages to one of the victims. And Sheriff Baca announced his retirement shortly thereafter. And the Sheriff's Department began to seriously apply itself to cleaning up the mess for the first time. A new leadership team has been brought in that has been following the recommendations of the Citizens Commission. And so reform is already underway in LA County jails, and we believe that this case will be settled in a way that makes that reform permanent. So I will end these remarks by saying that, again, repeating that prison litigation can be a powerful tool for helping to bring about far-reaching changes in our society. And what I believe is that its power is greatest when legal theory emerges directly from an authentic experience of suffering, of human suffering. And in some way, it is like epic poetry. Prison litigation can help give voice to the voiceless and empower the powerless to resist oppression. And it can inspire others to realize that we are all interconnected. Martin Luther King said it best in his letter from the Birmingham jail, and I'm quoting, "We are caught in an inescapable network of mutuality, tied in a single garment of destiny. Whatever affects one directly affects all indirectly. Anyone who lives inside the United States can never be considered an outsider anywhere within its bounds." It's a very great pleasure to be here with you, and I look forward to having a discussion with you now.
Thank you so much for coming to speak with us and sharing these really powerful experiences. My question was, earlier in your talk, you described how one of the judges you were dealing with tried to bar your ability to have contact with prisoners that you were seeking to serve. And I was curious, what would the legal basis be for making an order like that?
First, I will explain what the motive of it was. Some years earlier, a lawyer, a Mississippi, sixth-generation lawyer, Mississippi lawyer, had gotten himself appointed as class counsel for the prisoners with HIV in a way that, did not even begin to comport with the strict requirements for class action litigation to protect the class. They're very strict procedural processes for how a class action can be certified and how class counsel is chosen. And this judge did not realize, didn't understand, that the lawyer he had appointed as class counsel in this crazy, illegal way, basically, was doing nothing to help the prisoners. What he was doing was making it impossible for them to get into federal court because under an odd way that Mississippi judicial opinions had been structured, the sole way you could get into court for injunctive relief in a prisoner rights case was through this man, whose name is Ronald Welch. There is no other way. And he did not they would write to him and he would not do anything. He didn't get them. They wrote to him about the HIV issue, the medication, and he said, "Hey, I don't have the money to hire an expert, and basically you're all a bunch of crybabies." Not basically, he was quoted as saying that in the media. And so I think it would be the judges have tremendous discretion as to who to appoint as class counsel. Of course, in this case, the judge hadn't followed processes. There essentially was, and the prisoners in their, essentially 100% of them were petitioning to have the ACLU be their lawyer. But the judge did not want to get rid of his appointed class counsel, who he believed in. I think this was genuine. He thought, this is a good lawyer, and what are these, basically, what are these Yankees doing coming down here and throwing out this good lawyer? It's insulting. He didn't like it. But the judge is essentially a very, very good man who was so disturbed by the prisoners not getting the medication that he very quickly entered an injunction on the medical. But he wanted us out of the state. We needed to be there to enforce that order. And so the short answer is there was no legal basis. But when I could not believe that he said in an off-the-record emergency telephone conference, untranscribed, I said, I don't really understand. I've got to go up to Parchman to see the clients. What do you mean? And he said, I've made myself clear enough. Well, he hadn't really. At any rate, I drove up to see the clients, as I had done many times before, and I was met at the gate with a court order saying, saying what I just said, and saying that I had to show cause why I should not be sanctioned for alienation of affection of the class from your previous lawyer. So it was a trickier issue about the Fifth Circuit saying, yes, the ACLU, that's who the prisoners want, that's who they should have. But it was a slam dunk about the gag order. There was zero basis. So.
Thanks so much for coming down. Really, really amazing stories. Really appreciate them. One of the things you mentioned toward the end about the LA case was that you were able to extract punitive damages from the sheriff. And one of the things I think we've seen in a lot of similar issues we've discussed in this class and others is that it's very difficult to overcome qualified sovereign immunity issues for government officials. So I'm wondering how you, in that case and other cases, have been able to hold prison officials accountable despite sovereign immunity.
two things. One, those damages cases were not brought by the ACLU. They were brought by incredibly good, stunningly good, and many of these cases were by a really brilliant trial lawyer, Ron Kay. And so we didn't bring those. So I'm not really an expert on that issue, but essentially those are tort cases. But the ACLU does not bring damages cases. What we are doing is bringing, or at least my branch of it doesn't, we are bringing cases for injunctive relief. And when you bring an action against the state, because of the sovereign immunity bar, there is a legal fiction, which is an open fiction. It's not, everybody admits that's what it is. It's a fiction. The defendant that you name is the government official. So our cases were always against Commissioner Epps in Mississippi. It's not that we were seeking damages. We were suing him in his official capacity. And if he left and there was a new commissioner, the new commissioner would automatically be substituted as the defendant. And so there is no sovereign immunity bar for suing a state official for injunctive relief as opposed to damages.
I also want to thank you for coming. Your remarks, though brief, have been extremely emotionally compelling to me, and I'm sure that's magnified in your career as a whole. So in light of that, I'm wondering how you have managed or attempted to maintain your own emotional fortitude and just mental sanity confronting these what seem like truly horrific conditions for decades on end.
That question gets to me because in the first year, I found it so horrible that I said it would be too graceless to quit after 3 months or something. I'll stick it out for a year because it's just the barrage. To spend days in prison and to talk to people, realizing every single one of them is a human being and that the jail is, the society inside the jail are poorer than, in general, than the rest of society. They are disproportionately black and brown people in the jail. But what is the same is that it's the whole spectrum of human nature. And so you will meet people that you wouldn't care to hang out with. You will also meet the most, noble, good and gracious people, and selfless and altruistic. And so it's horribly painful to be up close to the suffering, but at the same time, you know that you can make a difference for them. And that is what makes it bearable. There's only two options. One is to close your eyes and run screaming away from it, and the other is to just dive in. And it is exhilarating to know that it's all about making it change, about forcing an institution, a government institution, to change, which is very difficult. And the prisoners themselves, the great people that you meet there, play such key roles and are such an example so that you feel ashamed to back off. If they're living the experience and they have the courage to be a part of it and to subject themselves to horrible retaliation and not to lose their mind, but to keep thinking and working on the behalf of everybody. It's a tremendous inspiration. The first year that I was there, I was horribly depressed. I was very, very, very depressed. And that turned, I don't remember at what point, into a kind of an exhilaration. Like, this is the most, what a privilege to have this work. It's like you know, the adrenaline is going, and it becomes the opposite of depression. It becomes a kind of exhilaration. But students who come in, you know, and they're first exposed to it, you know, people get, it's something resembling PTSD, and you know, it's understood that there needs to be counseling available. It's recently people have figured out that people who do this work when they first start doing it, or maybe for a long time, need to be able to find some way of dealing with the emotional disturbance.
So I have a question. Can you talk about what role, if any younger lawyers in the ACLU, maybe under your supervision, played in this case, or was it primarily you and
in
one or
which
two
case?
other?
In all of these
Sorry,
cases?
in the Mississippi case or in the California
Oh, in the
case?
Mississippi case? Well, a real big role. I mean, a huge role. These cases are very big, and they require a lot of boots on the ground to go into the prison and to interview. And also, in many of these cases, notably the Alabama case, there's a huge amount of briefing on complex issues. And every aspect of the litigation, they're, you know, very new lawyers, some of them, you know, not yet barred, playing central roles in the case. In the Alabama case, we got a you know, special exception from Judge Thompson in the middle of the trial to allow a young lawyer who wasn't yet eligible to be admitted to the bar of Mississippi. She was admitted to the New York bar to participate in the trial, and she got up and started doing cross-examinations, and, you know, wonderfully, of these so-called minor witnesses that you never have heard of before the trial, so you have nothing on them. You've got nothing on them. You have to be able to figure out in your feet, and with no experience, she was doing these killer cross-examinations that in 3 minutes, 5 minutes, she'd find some point to disgrace them. And the judge turned to me and my opposing counsel at one point and said, "Mr. Lunsford and Miss Winter, why can't you do something? You know, what is all this long-winded bullshit? Why can't you do what she just did?"
We have time for one more question.
So I guess one of the things that came up during your talk, and again, like others, I want to thank you for coming, is that a lot of prisoners' issues and like prisoners' rights don't get publicity because there is a sense in American society that, I think at least, that whatever happens in prison, they deserve it. And that also ties into this industrialization of prison, that now it's this fast-growing economy. So there's other motives to not address the problems. And so what do you think, not just in terms of litigation, but legislative options are there for addressing many of these issues on a broader, more nationwide?
Well, the legislation and the prison victories, I mean, they go hand in hand. It's very meshed. It's different aspects of the same effort, which is a public education effort to make people care about these issues, whether it's legislation or whether it's litigation. And the way that you do that is to make people connect. It is like only connect. Once people can connect with that experience and they get it, that this is a person like them, that the people on death row, I mean, they are not better. They are not superior. It is them. You know, that is the whole, what it's all about. And it's in that way that I mean that this is about poetry in some sense. It is about, it's not some dry legal theory. It's not writing a clever piece of legislation, although that, that's all part of it. That's an indispensable part of it. But none of that gets you anywhere unless you can make people make that connection, that it's about them, it's their father or their daughter who is suffering in that jail. And in the many of my cases, not the early ones that I talked about, I had like no apparatus for working with the press. But the latter cases that I've been telling you about have gotten big national media. And that is part of the big job that you have, whether you are working on legislation or other kinds of advocacy, court and other kinds of advocacy. It's all about being able to tell a compelling story. And it is compelling because you dive into the truth. That's why talking to the clients, talking to hundreds of prisoners, literally, is the only way finally to understand what is this case really about? What's it really about? What is the big issue here? And that only emerges. It never emerges sort of out of your own mind. It emerges from the direct communication, the experiences of the people who are experiencing and suffering from this, and they will be able to explain to you, if you will listen, what this is really about, and then you help give them the voice. So over the last several years, what seemed impossible before is becoming possible now. There is a very big anti-mass incarceration campaign, and for the first time over the last few years, in decades, if ever, there is an openness for people to connect to these issues. So.
We're going to take a break now, and please join me again in thanking our presenter, Margaret.